I'm for the respondent.
By this time, my lord, have come across to the legal position which is prevailing in these islands. If I am a beneficiary of a will, no profit is required. I have to simply make an application to the concerned person which I have made in the present case twice. Now he has to effect mutation based on such thing.
And see, if there is any dispute, then he will ask. He will
The person who disputes the will have to lodge a civil suit.
civil suit.
Yes, that's all.
So what is the problem here?
Will is there my application for mutation pending for consideration for a constraint period. The customer has to be directed to take it.
Yes, this is a law, madam.
Mine.
Within a reasonable time. But you have to serve notice upon the other side.
Sorry, sir. There's no.
Oh, only Tehsil then.
Only that's
So
the.
So you are the sole.
Yes, ma'am. Sole respondent, I am appearing on behalf of the Tehsil.
Arun, the learned counsel for the writ petitioner has submitted that he, you being the executor,
Page 10.
what is the beneficiaries?
Unfolded.
Yes.
কি বললাম? That the petitioner being the sole beneficiary in respect of a will dated 8/2/2008 executed by the recorded tenant late Vikraman Nayar has filed an application before the Tehsildar Andaman Nicobar Federal Ganj Tehsil for recording his name as a tenant in the relevant property remain unattended for a considerable period from the side of the respondent. Stop. If the respondent is not directed for taking expeditious step in dealing with the said application for mutation in accordance with the relevant regulations, the regulations, I think, 1966. 1966, regulations 66, or the Andaman, yes, 66. The petitioner will suffer irreparable loss and injury. Stop. Para. The learned counsel, Miss Bobita Das, has submitted that if the has submitted that as per regulation 1966, the concerned Tehsildar is under an obligation to take steps in respect of the prayer for mutation in accordance with the relevant provisions in this regard. I've considered the materials on record and find merits in the submission of the learned counsels of the parties. Stop. In view of the aforesaid, I direct the Tehsildar Ferarganj from a district of South Andaman to take appropriate steps in respect of the application for mutation filed by the writ petitioner. When you have filed,
The first one is at page not 12. Page 16, 12, 2019. Immediately after the death of the uh, person who executed it. 16, 12, 2019. Page 12, and there are 2, 3 reminders also.
on 16/12, 16/12. 16/12 or 2?
16, 12.
There's a
12. 12. You have to find at the top seat.
oh,
Office seat.
16/12, 2019. একটু বলো আমাকে, একটু একটু। As expeditiously as his office bearers can do so, preferably within 6 months.
2019 application.
Oh, 2019, huh?
I have
6 months is sufficient.
reasonable time as per the statute. to
Okay,
do-
within a reasonable time after complying with the provisions of regulations
Accordance with law.
in accordance with law prevalent in this island.
Yes.
Okay. That's all. With this direction, the writ petition such and such is disposed of.
Since affidavit has not been called for. law,
As the affidavit is not
Not to be admitted.
the allegations in the writ petition is deemed to have been not admitted, okay, by the respondent. That's all.
My obligation.
I am thankful to all of you for giving me this opportunity to serve the people of this island. I'm really very happy and convey my heartfelt thanks to all of you.
Pleasure is all ours.
Yes,
Pleasure is all ours.
pleasure is ours.
Okay.
Obligation. I'm there for the election.
And it's seek for an Passover. Who is for the other side? Hi, is Mr. Santanu Karmakar. The divisional application being such and such is dismissed. No order has passed. Next.
I'm appearing for the respondent.
I have gone through the schedule of proposed amendment, and it appears that there are two schedules of the proposed amendment. In the first schedule of proposed amendment, there are certain matters which are already parts of the record, and it is admitted by both the parties that they are parts of the pleadings of the petitioner husband in matrimonial proceedings. However, I find that the first schedule of proposed amendment in serial number A, B, C, and M are already on record, and therefore there is no need for further incorporation of such facts in the body of the written statement. However, it appears that if the para number D and E of the first schedule of the proposed amendment are allowed to be incorporated in the written statement, it would not prejudice the petitioner husband in the matrimonial proceeding, since they are the matters of documentary evidence and are known to each of them. Accordingly, even the learned counsel, sorry, I need some counsel for the wife. No, sorry, for the husband raises raises objection for insertion of such facts to the written statement, I find that no injustice would be done to either of the parties if para numbers D and E in the first schedule are allowed to be inserted in the written statement of the respondent wife in the matrimonial proceeding. However, so far as the second schedule of amendment is concerned, it appears that the said schedule of amendment is nothing but an attempt on the part of the respondent wife to incorporate a prayer for grant of a decree for restitution of conjugal rights in her favor. If we consider the case law of Ashok Kumar Kalra Supra, we find that the Honorable Supreme Court in an unambiguous manner has been pleased to lay down the outer limit for filing counterclaim, which, according to such observation, shall not exceed beyond the date of framing of issues. In this case, though the witness action is yet to start, I find that such second schedule of the proposed amendment in the application cannot be allowed in view of such settled position of law. Considering all aspects of the matter, I allow the instant civil revisional application in part. The order dated 3/4/2025 passed in MAT suit number 242 of 2023 before the learned judge family court is set aside. The petitioner wife's prayer for amendment as mentioned in para D and E of the first schedule at page number 2 of the amended petition of the wife be allowed to be incorporated in her written statement without prejudice to the rights and obligation of the parties involved in the said matrimonial proceedings. The proposed amendment as mentioned in the second schedule in the aforesaid petition stands disallowed. The parties are also directed to adhere to the time limit as directed by the Honorable Court in this regard by order dated November 6, 2024 in CO 41, 2024 in letter and spirit. The civil revisional application such and such is thus disposed of. No order as to cause. Let a copy of this order be sent to the court of learned judge, family court, Port Blair immediately.
Obliged.
এই চলে গেছে Mr.
Please, my lord, I'm appearing for the respondent in item number 4. Am I audible?
This, my lord.
New motion.
My lord.
So you are for the petitioner. Who is for the petitioner?
I'm appearing for the respondent, my lord. Am I audible?
This
Yes,
is a
yes.
revision.
Yes.
for
My
the-
lord, I just want to point out one thing before my learned friend begins to make submissions. I have only been served with a copy of the petition last night, that too after office hours.
So who is for the petitioner?
I'm for the petitioner.
You're for the petitioner, revisionist. You're for the
My
revisionist.
lord.
And he's for
Private respondent.
Respondent.
Case of 138 of NI Act, my lord. What had happened? I was directed to deposit the 20% amount as per 143 subclause 2. When I approached before the first appellate court, that is the session court, there is no specific direction whom I have to pay the money. And the time period of 7 days got lapsed because my client hails from Gujarat. So I have come before this honorable court for extension of time, and I'm ready to pay if a direction is given to me that I shall pay it to the appellate court.
So are you agreeable to his proposal, madam?
Lordship, I want to point out there's an order passed by this honorable court itself directing him to deposit 50%, and he has not challenged that order. In
Oh.
view of that order, he suppresses that order and he approaches the sessions court with a fresh application saying that direct me to deposit 20% only. My lord, now in view of this honorable court's order, he was supposed to be challenging this order, and this petition itself is not maintainable.
So you have been
And my
direct,
lord,
My lord, may kindly come to page number 50 of my petition once, my lord.
50.
5050, order dated 14 November 2024. First para itself, my lord.
Yes.
The appellant is relieved by judgment and order dated 3rd of October 2024, passed by single bench of this court, whereby the appellant accused in a proceeding under section 138 of Negotiable Instrument Act was granted leave to deposit 20% of the amount as a precondition for admission of the appeal against the order of conviction dated 26th 9/2023, passed by the judicial magistrate. second court at Port Blair in CR case number so and so. Now, continuation to this order, my lord, kindly come to page number 52.
Just a minute, just a minute. Judgment and order to the person of this court, however, the impeded accused in a proceeding under section 130 was granted leave to deposit 20% of the amount as a precondition for admission of the appeal against the order of conviction passed by. So there is a order of honorable single bench.
My lord,
Where that order?
my lord, may kindly come to page number 52, my lord, in the same order. One reference is there by the honorable court. Page number 52, para number 13, my lord.
52,
Para number 13.
13. Yes.
Yes, only reference is there. In most cases, amount not less than 50% of the value of instrument are ordered to be deposit as a precondition for admission of appeal by the session court. This is just an observation. But if you are, my lord, may kindly see 143 subclause 2 of the Negotiable Instrument Act, it says 20%.
Now, what is the order of the
The
Learned
respondent,
Learned
trial
trial
court,
orders? I want to go through.
it starts from page number 14, my lord. This is the judgment. And the operative page is, my lord, at page number 43,
43.
my lord.
Yes. 43.
An amount of 20 lakh was ordered against me. 28,
And he is apparently convicted.
my lord.
He's to suffer a sentence of 7 months. Is he have a sentence to suffer civil imprisonment for 7 months? There's further to pay 28 lakhs
My lord,
only.
only.
And the entire amount of the said fine be given to the complainant, namely Procastimon said as compensation. The convict shall pay the said fine compensation to the complainant within 1 month from the date of this order, and in default, the convict is liable to suffer simple imprisonment for a further term of 4 months.
4 months.
So here he has mentioned that the compensation shall be paid to the complainant according to
My lord,
the order.
this is the check amount, and the check amount was awarded to the complainant.
Yes,
So against that, I preferred an appeal before the learned session judge.
yes.
In that, I was granted stay, my lord, for operation of the order. The other party, that is a private respondent, they challenge in a way of writ before the honorable single bench. The order is at, my lord, kindly come to page number
I want
47.
I want to see the stay orders. Have you filed stay order of the?
My lord, may kindly come to page number 46, my lord.
Just a minute, just a minute, just a minute. Just a minute. 46.
My lord.
46. Yes,
May I read, my lord?
yes.
This application under section 374 subclause 2A of the CRPC filed by the appellant Hiren Babulal Adani against the impugn order judgment dated 26th of September 2023 passed by the Learned Judicial Magistrate First Class 2 Court, Blair in CR case number 27 of 2020. Peruse the application. Petition under section 374 subclause 2 capital A of CRPC has already been registered as criminal appeal number 9 of 2023 through the centralized filing center. Revisionist filed another application for staying the operation of impugn order judgment dated 26 September 2023 passed by the Learned Judicial Magistrate First Class 2 Court, Port Blair. Heard the learned advocate for the appellant. Peruse the case record. Considering this court find that there is a law point involved in the present application, and as such the application is admitted in the further proceeding of CR case number 27 of 2020, and the order of conviction is hereby stayed till the disposal of the instant appeal. So there was no 20% order was passed by the appellate court.
There is a wrong order. Even
And
if
this is
you
still-
want to file, if you want to file an appeal,
It is mandated, my lord, under section 143 subclause 1, my lord, it is mandated.
who passed
Now,
it?
my lord, this order was challenged, which is at page number 47. My lord, may kindly come to page number 47.
Yes.
By way of a writ petition, this order was challenged.
Yes.
My lord, the stay was vacated. The operative portion is page number 49.
Yes.
Even in that, the private respondent did not claim for 20%, my lord, as per 143 subclause 1 of the NI Act. The operative portion, my lord, may kindly allow me to read from the second para. It appears that the impugn order has been passed without any application of mine and without affording any reason whatsoever. the procedural requirement which the court was obliged to adhere to has not been followed, then the reference of case is there. In such circumstance, the impugn order of stay of the judgment and order dated 14 November 2023 stand vacated. There will be an order in terms of prayer A of the application with the above direction, WPA number so and so stands disposed of. Now thereafter what had happened, my lord, we filed a CAN petition which is at page number 50. Wherein the court has held that 20% is mandatory, which I referred earlier, my lord.
Yes.
And in that one reference is there at para number 30, which appears at page number 52. Para number 13, court says, my lord, it was the opinion I can say at the best of the court. In most cases, amount not less than 50% of the value of the instrument are ordered to be deposited as a precondition for admission of appeal by the session court. But the law says, my lord, it is 20%. 143 subclause 1 says 20%.
Yes.
So I pray before the court, that is, my lord, may kindly come to page number 55.
55.
55 in the appeal court with my petition under section 430 of the BNSS, I filed a petition for depositing. Court said that the 7 week
55, no?
55, my lord, 55
Okay.
starts from 55 and the operative portion starts from 56. So what had held, my lord, by the court is that since 7 days time was granted to me, that has been lapsed.
Ah.
So a warrant was issued against me. I pray for depositing the same. It was not allowed since the Honorable High Court has passed a direction of 7 days. Since the client hails from Gujarat, it takes time to reach here. And then the warrant was issued. So I have come up before this Honorable Court, my lord, and in that order, I beg pardon to mention this, my lord, but there was no specific direction whether it has to be paid to the appellate court or to the learned trial court.
I think that what is the minimum amount to be
My lord, oh,
My lord, may
if the petitioner is done making his submissions, or lordship, may I make my submissions?
kindly come to
Let
one.
me
Yeah.
point out.
yeah, just a minute. 1 minute.
My lord, kindly come to 148 of the NI Act, my lord.
Negotiable instrument একটা কোথায় আছে একটু দিন please read
My lord, it says, my lord, power of appellate court to order payment pending appeal against conviction. Clause 1, notwithstanding anything contained in the Code of Criminal Procedure Code, in an appeal by the drawer against conviction under section 138, the appellate court may order the appellant to deposit such sum which shall be a minimum of 20% of the fine or compensation awarded by the trial court, provided that the amount payable under this subsection shall be in addition to any interim compensation paid by the appellant under section 143A. Now subsection 2 says the amount referred to in subsection 1 shall be deposited within 60 days. But I have been granted only 7 days by this honorable court, and he hails from Gujarat, my lord. He has to travel
so
from Gujarat.
you have got sufficient time after passing of that order.
Now the difficulty is, my lord, there was no direction to whom I have to pay. Even I am ready to pay, my lord, today itself in the registry, if my lord directs me, because the difficulty lies, my lord, in order number 54.
Registry
My
of
lord,
which court? Registry of
in the High Court if allowed, or in the appellate court, anywhere, my lord.
appellate court,
That is the session court, wherein the appeal is pending.
not sessions court. Yes.
Yes, it is sessions court, my lord.
So
My
now
lord, there is a specific direction by this honorable court that if he does not, my lord, I am not able to hear. If he does not deposit the money, then the sessions court will not hear the appeal and a conviction warrant will be issued, and it has already been issued. Now my learned friend is running to this honorable court. There is already an order by this honorable court. Now he cannot seek recall of that order. If he is aggrieved with this honorable court's order, he ought to have filed a MAT, or he ought to have approached the Supreme Court. Now, my lord, let me point out the conduct of the petitioner. My lord, he has obtained ex parte stay. He is convicted by order dated September 2023. For 1.5 years, he enjoys his.
just say, I want to know whether 50% and 20% as per statutory provisions. This is a 20%.
My lord, 20% is minimum. Discretion lies with the court, with the sessions court, as to how much percent to direct him to deposit, my lord. And there is the order of this honorable court itself directing him to pay 50%. Now, if there is
Just a minute. Your client is right now here.
He'll come within 48 hours, my lord.
No, you have to pay the amount. I think you have said that your client has come from Gujarat.
No, he's ready to pay, my lord. He's ready to pay. Let it be on Monday, he'll come and pay it on
Monday is
Monday.
a holiday, I think.
No, here we don't have holiday, my lord.
No holiday.
No holiday. High Court is holiday, trial court is going on.
Yes.
May I just kindly come to page number 48 of the petition, Lordship, for a minute?
Money.
My
Yeah,
first
For me, allow me to take the money. I fail to understand.
Okay. Now I have to hear.
I beg pardon. I beg pardon.
Allow me to make my submission. I am grateful, Lordship. My Lord, he obtained ex parte stay without serving me any petition in the appeal. For 1.5 years, he enjoys the ex parte stay. My Lord, there is no delay application in the stay. There is no suspension of sentence application. There is no compliance of section 148 for minimum 20%. Therefore, I challenge that stay order before this honorable court. This honorable court passed order on page number, that order is at page number 48. My Lord, may I read the relevant portion which clearly records the conduct of the petitioner?
Just a minute. I want to go through the relevant provision 141. No,
148.
143, my lord, subclause 148 clause 1, sorry.
148.
148.
Just a minute. Just a minute. 148. Power of appellate court to order. So minimum of 20%.
Yes.
20% is minimum.
Minimum.
So he seeks sorry, she seeks 50%. That is a problem.
Yes.
My lord,
So-
somewhere in between 20 to
Somewhere
50.
30. Hey, Asu.
30.
No, my Lord, at least allow me to make my show. Let me complete my submission. Page number 48. Just for a minute, I will not take this honorable court's much time. Page number 48.
I have been paid for that. So
I'm grateful, Lordship.
when you are in the chamber, you should have come here and participated.
Very-
Okay, tell me.
Yes, my Lord will just see page number 48 for a minute of the petition.
48. 48. Yes,
Last paragraph.
the matter has been heard on several occasions. Yes.
Yes. Well, I'm sorry, paragraph number 2 from the top. It is submitted on behalf of the petitioner that there has been an inordinate delay in filing the application. There is no compliance of depositing 20% as a precondition to filing the appeal. There are no reasons for granting an order of stay of this nature. There was no application for suspension of sentence. My lord, thereafter, the last paragraph, the advocate appearing on behalf of the private respondent, that is the accused, the petitioner before this honorable court today, had assured this court at a prior hearing that they were ready and willing to make payment of the entire amount within a period of 3 months. Thereafter, in view of the interest component, the respondent had agreed to take instructions. It is now submitted on behalf of the respondent that they are neither ready nor willing to pay the principal, leave alone the interest amount. The conduct of the private respondent, to say the least, is reprehensible. My lord, while this order of this honorable court, the stay was vacated. In view of that, I moved an application to issue a conviction warrant. My lord, my application was pending. Therefore, I again came to this honorable court, filing a revision. In that, my lord, in the meantime, this order was challenged in MAT by my learned friend, wherein the MAT court also records at paragraph number 3, page number 50.
Yes.
Such unconditional stay without assigning any appropriate reasons is extremely unusual and borders on illegality. In that view, the impugn order directing the payment of 20% as a precondition for staying of conviction passed by single bench cannot be faulted. Thereafter, paragraph 13. In most cases, amount not less than 50% of the value of the instrument are ordered to be deposited as a precondition for admission of the appeal. My lord, thereafter, I moved this honorable court again by filing a revision. That order is at page number 54. May I
Yes.
read paragraph number 1? In view of the fact that the order dated 14th November passed in MAT has not been complied with, the appellant shall not be given any preference for hearing of the appeal without the amount as be directed in para number 13 of the said order is complied with. In the event the said amount is not deposited within a period of 1 week from date, prior for issuance of warrant of arrest pending before the JMFC court, shall be deemed to have been allowed and appropriate steps shall be taken to issue warrant of arrest against the appellant. On fulfillment of the condition of pre-deposit, the learned sessions court should hear the appeal on the next day. My lord, he has not challenged this order. Today, this order still holds the field. If he is aggrieved with this order, if my learned friend feels that this order is ambiguous or there is no specific direction, then he ought to have filed for clarification or approach the higher courts. Now, in view of this order, what my learned friend does is he moves a separate application. After 1.5 years, he moves an application for suspension of sentence and then requests the sessions court that pass the direction against me to deposit only 20% when there is an already a direction for 50%, and he does not even annex this order of the Honorable High Court. Fortunately, my learned colleague present in the courtroom today was present before the sessions court, and he pointed out that, Lordship, this cannot be done because the Honorable High Court has passed an order on 12th of March. After which the sessions court rejected his application for suspension of sentence because the Honorable Court's order clearly directs him that if he does not deposit the amount, the appeal will not be heard. So the suspension of sentence application also could not have been entertained. And that is precisely the reason why the sessions court has rejected the application. And now, after 1.5 years, he's been enjoying the stay. Now, today he is saying, allow me to deposit only 20%. That cannot be done, my lord. The conviction order was passed in 2023. Today we are in 2025. I have been deprived of this money since, my lord, since 2019, from when the check was bounced.
You have sufficient opportunity to deposit it.
My lord, kindly come to page number 56
No,
once.
whatever it may be, there are so many.
My lord, may kindly come to page number
I shall
56
not
once, my lord.
ask you to pay 50%.
My lord, kindly appreciate
And
one thing.
the concerned person to arrest
My
your
lord,
client.
kindly beg pardon, but kindly come to page number 56
I
once.
shall not go into.
My lord, may kindly see the order of the Honorable Session Court.
Is there any problem for your client to understand the order of the
My
court?
lord, may kindly come to page number 56 once, my lord.
He did not have the opportunity to have legal.
My lord, kindly see the
Competent
page
legal
number
advice.
56. I approach before the learned
I
Session
do not
Court.
know whether you will pay 50% right now or not. Whatever.
My lord, kindly come to page number 56 once. Kindly come to page number 56 once, my lord.
Yes.
I move petition before the Session Court, Learned Session Court. Learned Session Court has rejected my petition on the plea that 7 days time was granted. But statute says 60 days time. I hails from Gujarat. At least some concession of time should be given to me.
No, I cannot give you any time because you have sufficient opportunity to move this court.
My lord, at this stage,
Only after 3 orders passed by this honorable court, today my learned friend is saying, allow me to deposit. This cannot be
the
done.
only condition is that I need a weekday's time.
No week.
I have to travel from Gujarat.
So today in digital India, there is no
Online can I
fraction of.
my lord, can I transfer online? Can I transfer online? Let the order be there.
Yes.
I will do it.
Transfer.
I will do it online.
To the account of the complainant.
No, it has to be deposited in the appellate court, my lord.
True.
It has to be deposited in the appellate court.
So to your
Tomorrow if I succeed, my lord, tomorrow if I succeed in the appeal, how will I recover that money, my lord? That is the question. So I ask
to your account to deposit, no problem.
My lord, if he succeeds in the appeal, I am ready to refund the amount. At least some amount should come in my account. This check has bounced in 2019. Today we are in 2025.
Receive the money, I'll pay it on Monday.
What?
In the Session Court, appellate court.
50%.
The difficulty is that no order, every order is silent where I have to deposit the money. That difficulty has arose.
Registry of the appellate court.
My lord, that difficulty arose. That is why my petition was rejected.
So 50%.
My lord, to the Session Court. To the Session Court.
Azur, the learned counsel for the appellant or revisionist has submitted clearly that his client wants to deposit 50% of the amount at 50% of the amount of the fine or compensation.
Yes, the amount that has been directed to pay is 28 lakhs, so 14 lakh.
28 lakhs. 28 lakhs. That is 14 lakhs. 13 lakhs to any of the office of the court as would be directed. Stop. Para. The learned counsel for the respondent has submitted that she has no objection if the petitioner is directed to deposit 50% of the amount of rupees 28 lakhs to the registry of the to the office as would be directed by this court. Stop. In view of the above submission, I direct the petitioner / convict to deposit 14 lakhs to the registry of the district and sessions judge, Port Blair, by Monday, কত তারিখ হচ্ছে? হ্যাঁ 14 by Monday 14 within 4 hours without fail, and on payment of such money without subject just delete this portion, without prejudice without prejudice to the rights and without prejudice to the rights of the appellant convict. Okay.
Lordship, may
Just a minute, please. He has accepted, your brother has accepted. You must be thankful. And you must be grateful to me, and you must be thankful to him. Okay.
I am obliged, Lordship.
Without আগে কি বলছিলাম? না, on payment of on deposit of such money with the registry of the concerned court, comma, the warrant of arrest which has already been issued should be recalled on the prayer of the appellate convict.
My lord, just two things, my
A
lord.
copy of this order sheet be sent to the
It should be, my lord, treasury of the district court, not
treasury of the
treasury of
district
district
court.
And my lord, second thing, my lord, since we have made a representation to the Honorable High Court Zonal Judge for declaring Monday as holiday, if suppose today evening we get some response, so my lord may kindly fix it on Tuesday.
Tuesday, okay?
Tuesday.
Not Monday. Miss.
A day will not make any difference, my lord.
May I-
Intention is very clear. Just make
Yes,
payment.
very good.
My lord, just one additional, may I only seek one additional direction? Let the appeal be heard on the next date.
This word that
Right.
Mr. Govind has fairly submitted.
I'm grateful,
Okay.
my lord. I'm grateful, my lord.
Okay. কি বললো ওটা? Port Blair for his information and necessary action. With this direction, the present criminal revolution application is disposed of.
My lord, only, my lord, let this be pending at least if the compliance is done or not. Let us see if the compliance is done. Otherwise, there'll be one more order hanging on our head. Let's wait for one date if the compliance is done or not.
No, there's a provision. I don't know whether complaint, whether this, if he did not comply with if he does
No,
not comply
we'll do it,
with
my lord.
just whether a contempt application can be filed. This is a legal issue.
Whether?
If this order is not complied with, whether a complaint case can be filed against.
Warrant can be issued, I can be put behind the bar.
Warrant is already issued, my lord. Warrant will have to be executed. So my lord may at least record that if defaults,
Recalled only once I deposit, my lord.
That's why
if he does not,
What is hanging on my head?
virtual hearing.
I'm sorry, lordship.
No, if he does not
So it is hanging on my head, my lord. I have
fails
to
to deposit the money, warrant of arrest will be
affected.
pending and effected. Okay, there will be no problem. Okay.
Oblige, my lord.
My lord, may I request one thing? The appeal may be heard on the next date
Without
if
fail,
he complies with the order.
payment.
A court of law cannot function with the assistance of his.
My lord, I am
officers.
giving my words, my lord. Tuesday it will be done.
That's why it is called noble profession.
I am giving my words, my lord. Tuesday morning it will be done.
You are the secretary, no?
My lord,
Oh,
it will be done on Tuesday, my lord.
okay.
I am grateful, my lord.
Disposed of. Okay.
I'm grateful.
Amit Kumar Rishi.
Item 5, I have been called by the star and said that I have been to appear for the petitioner in this matter, my lord.
ভেরি গুড ভেরি গুড মিস্টার বিশ্বাস
জি স্যার, নমস্কার স্যার।
কেমন আছেন ভালো?
স্যার ততটা ভালো নাই স্যার, আপনার পরে সবকিছু স্যার।
আচ্ছা আপনার জন্য একজন উকিল বাবু ঠিক করে দিয়েছেন, ঠিক আছে?
হ্যাঁ
আপনার
স্যার।
একজন উকিল বাবু ঠিক করেছেন, খুব ভালো ইয়াং 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 অফিসার, হ্যাঁ, অফ দি কোর্ট। সো
হ্যাঁ
এটা
স্যার।
আমার মনে হয় আপনি ওনার ফোন নাম্বারটা আপনি একটু ওনাকে দিয়ে দিন,
I'm
কথা
not
বলে
having
নিন।
any details with regard to the petitioner, my lord, so that I will take from the.
বাংলায় বাংলায় বলুন, ও বুঝতে পারবে।
Lord, I can understand Bangla, but I am not able to speak.
ও সরি সরি, মিস্টার বিশ্বাস মিস্টার রাকেশ বলছেন, রাকেশ হোয়াট ইজ
Rakesh Kumar, ma'am.
মিস্টার কুমার,
রাকেশ কুমার।
হ্যাঁ,
জি স্যার। হ্যাঁ হ্যাঁ।
হোয়াট ইজ ইউর ফোন নাম্বার?
And 993332
So can I give it online? Just write down. 99
99732
99732
98742, ma'am.
9874
42, ma'am.
98742. Please repeat.
জি
बोलिए
স্যার,
क्या बोल
9933 স্যার 9933 98742 স্যার।
now you please give your phone number to Mr. Kumar. Okay,
Lord,
please.
let him send it in chat box so that I can collect it.
वो जाने ना हो तो। हाँ, आपका नंबर क्या है बताइए?
मेरा नंबर सर
हाँ हाँ हाँ
9531
9531
80
80
3577।
3577 9531803577.
হ্যাঁ জি স্যার।
So exchange your call. আসুন। সো উনি কিছু কাগজপত্র উনি চাইছেন, ফোনে কথা বলে নেবেন, হোয়াটসঅ্যাপে পাঠিয়ে দেবেন, সবকিছু করে একটা আমি মিস্টার কুমারকে বলছি যে ইট ইট গিভ সাম পেইন টু মি যে একজন
স্যার আমি
শুনুন,
জি
একজন
স্যার জি স্যার।
ভারতীয় নাগরিক, তাকে হঠাৎ ধরে নিয়ে যাওয়া হলো, ধরে নিয়ে গিয়ে তাকে বললো, মারধর করলো যে তুমি ভারতীয় নয়, তুমি বাংলাদেশি, বলতেই পারে বা করতেই পারে, ওকে সন্দেহ করতে পারে, সেটা নিয়ে কোনো অসুবিধা নেই।
But
You
I have gone through blood. But it
Yes.
is an injustice to be
But the thing is
Inquiry
that
has to be.
he is an Indian national,
Yes.
and for that he has also produced certain documents,
Aadhaar card.
but he has been mercilessly beaten up.
That's
and
an
you
allegation
can-
which is made in the
So
complaint.
then an insult. If a person is if an Indian is called that you are a Bangladeshi, it is certainly insult.
Sir,
It will cause some
What I
problem.
find, my lord, because he
He's a young lawyer. He will take up your matter. Don't think that. এবং
স্যার আমার কথাটা একটু শুনুন স্যার।
প্লিজ, আপনার কথা আমি শুনেছি, অনেক পড়েছি, কালকে রাত্রির জেগেও পড়েছি।
হ্যাঁ স্যার।
যেটা দেখলাম 156 একটা করেছে, একটা 156 ধারা করেছে, কিন্তু সেই অর্ডারটা কিন্তু নেই। লার্নেড ট্রায়াল কোর্টের যে অর্ডারটা 156(3) রিজেক্ট করার অর্ডারটা কিন্তু আমি দেখতে পাইনি এখানে, ঠিক আছে? এবং এখানে যেটা বুঝতে পারলাম যে অ্যাপিল কোর্টের বা রিভিশনাল কোর্টের একেবারে জাজমেন্ট লিখে দিয়েছে।
yes, and no medical documents, later medical evidence was produced.
অ্যাভেলেবেল স্যার, অ্যাভেলেবেল স্যার।
একেবারে জাজমেন্ট লিখে দিয়েছে, মানে প্রথম দিনেই একেবারে ডিসাইড করে দিয়েছে কিভাবে করতে পারে, এটা আমার লিখেছে। এবং সব থেকে আনফরচুনেট, দেয়ার ইজ সাম ইনফ্লুয়েন্স ইভেন অন দি পার্ট অফ দি
What I suggest, not because he's made an initial complaint, then that at least the trial
That
court
should
should
be-
have conducted an
Exactly.
preliminary inquiry to
but
know
don't
the
show
facts.
it by any consideration.
That has not been done.
Other advocates say that the accused has some acquaintance with them, family friend or something like that. That's why he. Okay, you please
Yes,
consider.
yes.
Okay, Mr. Rakesh Kumar has entered appearance and has submitted that he has been engaged by the State Legal Services Authority, Andaman and Nicobar Island, Port Blair, to represent Mr. Amit Kumar Bishas in this case. Stop. In view of the same, I direct and I request Mr. Kumar to go through the materials on record and to appear before the next available circuit to render justice to the petitioner in accordance with law. place the matter. ঠিক আছে, ওই একজন উকিল বাবুকে দেওয়া হয়েছে আপনার তরফে, উনি আপনার সঙ্গে যোগাযোগ করবে, আপনিও ওনার সঙ্গে যোগাযোগ করুন, ঠিক আছে? এইভাবেই ব্যাপারটা, আমরা কিন্তু ব্যাপারটা ছেড়ে দিইনি এখনো, আমরা দেখবো যদি আপনি ভুল করে থাকেন সেটাও দেখবো, আর যদি পুলিশ অথরিটি ভুল করে থাকে সেটাও দেখবো, ঠিক আছে?
স্যার আমি স্যার একজন স্যার গরিব মানুষ স্যার, ডেলি স্যার এরকম আপনার ডেটের সঙ্গে ডেট আসলে স্যার এইখান থেকে আমি 8 কিলোমিটার দূরে এসে স্যার ডেলি হিয়ারিং করি, আপনার সাথে কথা বলি স্যার। আর
শুনুন,
তারপরে উকিলের কথা স্যার আমার বিশ্বাস হয় না, কেননা স্যার আগেও আমি জেমএফসি কোর্টে যাই স্যার, আমার সঙ্গে এরকম হয়েছে, সিজিএম এরকম করেছে স্যার উকিলের সঙ্গে।
বেশি কথা বললে কিন্তু আপনারই প্রবলেম হবে, কারণ
হ্যাঁ স্যার, হ্যাঁ
আমি শুনুন যে কেন
বলি স্যার।
বুঝতে হবে, বুঝতে
হ্যাঁ
হবে।
হ্যাঁ
আপনি বলছেন আপনি গরিব মানুষ, কিন্তু দেখুন আপনাদের জন্য, গরিব মানুষের জন্য সরকার অনেক ব্যবস্থা করেছে।
জি
এইখানে
স্যার, জি স্যার।
নিজে মামলা করতে আসতেন তাহলে আপনার অনেক খরচ হতো, কিন্তু
হ্যাঁ
আপনার,
স্যার, হ্যাঁ
শুনুন ভালো করে শুনুন, আর
হ্যাঁ
আপনার তরফে একজন উকিল বাবুকে দেওয়া হয়েছে যে আপনার কেস লড়বেন এবং আপনাকে তার জন্য ফিস দিতে হবে না, সরকারই আপনার ফিস বহন করবেন, মানে ঠিক আছে?
জি
এইটা
স্যার, জি স্যার।
আর একটা কথা আমি বলে দিলাম, উকিল বাবুদের নামে বা উকিল বাবুদের সম্বন্ধে কোনো রকম বাজে কথা আমি কিন্তু শুনতে চাই না। প্রথম কথা হচ্ছে আমি
জি
এক
স্যার, জি স্যার।
বাবুর ছেলে, হ্যাঁ,
হ্যাঁ
আমি
স্যার, হ্যাঁ
উকিল
স্যার।
বাবু, আমি একজন আইনজীবীর ছেলে, এবং আমি
জি স্যার,
নিজেও একজন উকিল বাবু ছিলাম। তো উকিল
জি
এই
স্যার।
কথাটা প্রথমেই ভুল করে ফেলেন, একজন
হ্যাঁ
উকিল
স্যার,
রকম হতে পারেন, সেটা অন্য ব্যাপার, কিন্তু তার মানে
জি স্যার।
জেনারেল একটা যে উকিল বাবু মানে, সেটা কিন্তু বললে আমার গায়ে লাগবে, আর আমার গায়ে
হ্যাঁ স্যার,
লাগবে, বুঝতে পারছেন, মানে আমার মতো যিনি বসবেন তার, সেই জন্য কিছু কিছু কথা বুঝে শুনে বলতে হবে, অল্প কথা
হ্যাঁ
বলবে।
স্যার।
যেহেতু আপনার উকিল বাবু এসে গেছেন, আপনার সঙ্গে কিন্তু আর হয়তো নাও কথা বলতে পারে, ঠিক আছে?
জি স্যার, জি স্যার।
আচ্ছা,
জি
ঠিক আছে,
স্যার, জি স্যার। হ্যাঁ ঠিক আছে স্যার।
নেক্সট।
ঠিক।
Lordship, service is incomplete, let it be an accepted election.
The learned counsel for the
Appellant.
appellant has submitted that this matter should be placed before the next available circuit, as the service upon the respondent is incomplete. Please the matter before the available. Yes.
Lord, item 7, this is at MSCT, my lord, wherein I have been told to appear on behalf of the respondent to SLS.
You are for
I for the respondent, my lord, because he cannot appear.
the learned counsel for
He cannot appear.
why?
He is panel government counsel. He cannot appear against the government.
No, that is different thing. He has been engaged in the next matter, next circuit you will decide. Okay.
My objection is that he cannot agree.
Yes, I
He
shall,
cannot-
I shall record. But he's a government panel lawyer.
He cannot go against the government. He cannot take brief against government.
Oh, he's against government,
G.
whatever it means. It's junior, he's a junior.
I told because SLS.
অনেক কাজ করে
অনেক
বড়
কাজ
বড়
করে।
কাজ করে
বড় বড় কাজ।
এত বড় কাজ করে কত জুনিয়র বুঝে নাকি এ ভালো করে বুঝে
সব বোঝে না?
সব বুঝে ওর আছে এলাকায় আছে তো
Mr. Rakesh Kumar has entered appearance on behalf of the respondent being appointed by the State Legal Services Authority, Andaman and Nicobar Island. However, the learned counsel, Mr. Lal,
as a junior of me in this case
has submitted that he cannot, that Mr. Rakesh Kumar cannot represent the respondent, as he is a government panel advocate, and therefore he cannot stand against the issues relating to, against the legal issues relating to government. Stop. Para. So, stop. Para. As today is the last day of circuit, and on the request of the learned councils and learned council, list the matter before the next available circuit.
I take necessary.
So I also convey my thanks to all of you
Yes, yes.
for giving me for giving me this cooperation. And I'm really very happy that you have given this opportunity to serve the people of this island. Okay, this beautiful island.
Lord, so far as Milord, this is with
What is
regard
the
to
instruction?
court. Lord, I have been had 3 submissions, Milord, which have been insisted me to be placed before Lordship's instructed, Milord, on 3 issues. The first,
No, give them copy.
Lord, I am
Otherwise, how can they? No, give them copy. They will consider. Otherwise, it's a very serious issue. Now, I think that you should go through his instruction also. Otherwise, it will cause some problem. So, according to you, that rightly it has the
Yes,
registry has been rightly done. Then the Court Fees Act 1870.
Yes,
But
Milord.
why is your written instruction?
Lord, the written instruction, already the Honorable Court has passed an order based on this aspect only, Milord. That is under challenge.
Yes,
This is the Court Fee Act, Milord. This is a reference.
you file an instruction in written
Milord,
instruction. That was
District Court has said, Milord, with Milord.
you will
direct-
file a written instruction.
Milord, that's why I went and I
exempted
personally-
that no affidavit is required. So you have to file a
Milord,
written instruction. I have
requested.
to say anything against the judiciary also. Why they have claimed so much ad valorem court fees or something like that?
Milord, they say as because the order in passed by the
No, Mr. Kumar.
Lord, the order which is under Lordships, which has been assailed before the Lordships, wherein the Honorable Court has specified the reason under what circumstances why the Court Fee Act is applicable and they have to pay the court order, Lord. That is a order. I have requested the court under what is the provision, how the court come to this finding.
Yes.
So the court has come to, they have insisted me that Milord, the court fee, it may not be see chapter 3, computation of fees in Andaman Nicobar Islands. Lord, I will read 7(1). For money in suits of money, including suits for damage or compensation, or arrears of maintenance or annuities or other sums payable periodically according to the amount claimed. Lord, this is MSCT will become as a compensation, and it is to be treated as a deemed suit, my lord. If they are saying that it is an application, then the application.
The amount of fees payable under this act in the suits next herein after mentioned, except suits for relief under section 14 of religious or under section 9.
It is a deemed to be a suit, my lord.
For money in suits
Lord,
for
they
money.
going for an execution based on the award passed by the court. They are going for
No. According to him, he wants to impress us in suits for money, including suits for damages or compensation.
Yes.
Now, whether other application can be termed as
Lord, it is cannot be treated other application, Lord, because if my lord will see it, because award has to be executed. And if it
the
is an
suit can be barred by limitation.
yes, my lord.
Huh?
Yes, my lord.
The application for MSCT can be barred by limitation.
Lord, that cannot be. But even though
No, I do not know whether you agree or not. Now, Mr. Chakravarti.
What I understand is,
Now,
your submission, my lord, is what I understood that an application cannot be executed, whereas MLCT claim can be executed like a
suit.
So this is the
Because the
instruction
procedure of
which the court
CPC,
has
yes.
because it is treated like a suit. It is a capable of.
so what is that?
Like a decree. And secondly.
No, it needs a elaborate hearing.
That is.
I think the next circuit is I given sufficient time
Yes,
to
yes,
all of
sir.
you so that I can hear.
Sir,
But today is the last day. If you pressurize me, then it will.
No, I will not pressurize. There is a decision of the honorable.
And another thing is very unfortunate. Your family judge, your landed family judge has fallen, and I have he was my probationer. Ditendra Narayan Mitra.
Very sad news.
Very sad news, and I want to visit him. Now, today, if you pressurize,
No, my lord, please.
but I am really very much interested for this legal discussion.
Because
Yes, yes, my lord. Because it is a
My lord
benefit.
can mark it parchment, my lord, it can be. Not from the next one.
Then,
My lord is interested.
It can be parted also.
Can be done, but.
Please.
As my lord-
I am very much busy with so many
No.
criminal matters. Okay,
That's right.
welcome. The learned
I was
counsel,
relying upon the Honorable High Court's judgment, Your Lordship.
please, next slide, okay, sir.
Yes.
The learned counsel, Mr. Rakesh Kumar, has submitted on instruction that that he has been that he has been told that Section 7 of Court Fees Act 1870 is the basis for claiming ad valorem court fees by the
Andaman
Consent
Nicobar
court.
Islands.
in connection with the relevant matter. Stop. Para. The learned counsels appearing for learned counsel appearing for whom? For petitioner.
Petition.
Petitioner has opposed
Private response.
such submission. However,
Party.
the matter needs an elaborate hearing,
Party.
and as today is the last day of this circuit on the consent of the parties, this the matter before the next. Thank you.
Blair.
I'm
Sorry,
very-
my lord. Yes.
ঠাকুর, আর কিছু আছে? এটা? Yes. What happened?
There is a situation. The situation is.
Grave or
It's
Mild.
great. So I have come
Great.
to this.
always a grave situation? There is no time. Yes.
It's that very great that I have not brought the file.
So next circuit, please. This- As today's the learned counsel for the parties are present. However, today as the last day of circuit, on the request of these councils, this matter next circuit. So I convey my heartfelt thanks to all my officers of the court. Okay, thank you very much.